Hi, I'm Annie Fitzsimmons. I'm your Washington REALTORS Legal Hotline lawyer, and this is another episode in our series entitled, I Have to Read the Preliminary Commitment for Title? And the answer is yes, you do. And we have a subject matter expert here with us today to help you understand what you're reading when you read it. Jake, would you introduce yourself?
Sure. Jake Mensinger, a title officer, Vancouver, Washington. I'm working with First American, and I'm glad people are reading those title commitments.
That's right. Ordering and reading, right?
Yes.
In this episode, we want to talk about property that's held in a special tax classification and the significance of that. So listing brokers, when you're listing property, if the seller has not already mentioned, and so often they don't, it doesn't seem important to them or they've forgotten about it. When you're reviewing your preliminary commitment, what are the words they're going to be looking for to know that the property is held in a special tax classification?
Sure. Most of your title commitments are going to start out the same with your excise tax, your property taxes, and then under those, you're going to get an exception that's going to alert you to some sort of land use classification. Now, whether that's farm and agricultural, timber, open space, any of those, you're just going to see that. And then it's going to tell you what that classification is. So you will see that as a Schedule B, Part 2 exception to your title report. And then the question becomes, are you leaving it in land use or are we going to be taking it out of land use?
The reason it's in that special tax classification is so that the owner of the property can pay a reduced tax rate. If it's in timber or it's in open space, then the seller will have been paying lower property tax for as long as it was in that special classification than the amount of tax that was truly owing if it weren't in that special tax classification. Great benefit for the seller for all the years they've owned that property. But the county says, but we're going to get some of that back when you sell the property. And the law says that the county is going to get up to 7 years back of that reduced tax amount. Is that a fair description?
Yeah.
And the law says that it's seller's obligation to pay that amount, whatever the county says that amount is, and you have to rely on the county to tell the seller that amount. But the law says that it's seller's obligation to pay that amount when they convey title. So this is where your role on this issue becomes hugely important, listing brokers. Most sellers are not anticipating paying a huge tax bill, and it can be very large depending on the size of the property and
it'll add up, yeah. The tax man needs his money.
Yeah. It can be a huge number, much larger than the seller is expecting to pay as part of their reduction to proceeds at closing. And so if the seller for the first time learns about this issue when they're reviewing their draft settlement statement and they see this chunk of $28,000 coming out of their proceeds to be paid to the county, you have got a serious problem, listing broker. In fact, you're probably not going to get paid on this transaction because it's probably not going to close. But here's the good news. You've done your job. You've ordered the preliminary commitment for title. You've read the preliminary commitment for title, and you know that this property is being held currently by this property owner as open space in the open space tax classification. You also know that this seller is selling these 138 acres a developer who's going to develop the property and turn it into a subdivision. In other words, it will no longer be open space, and it can't be held in open space by this new buyer. So, listing broker, you know that this issue must be negotiated as part of the purchase and sale agreement. There's two forms where you can use to negotiate this. There is a provision on Form 22L&A, the Land and Acreage Addendum. I think it's paragraph 6, where you can negotiate the outcome of this scenario. And then there is a standalone form, I can't remember the number, but it's basically paragraph 6 of the L&A addendum that is just a standalone provision to negotiate this special tax classification issue. And it gives the buyer and seller the platform for negotiating whether seller's going to pay for the tax assessment or whether the buyer is going to pay for it, or whether they're going to share that obligation, or in a circumstance where the buyer could potentially continue to maintain the property in that special tax classification, there's a provision for the parties to negotiate that will be the outcome, that buyer agrees to hold the property in that special tax classification, in which case, if the county granted that permission, then there would be no assessment of taxes at the conveyance of the property. So, Jake, what is your experience with issues like this from the title company's perspective?
Sure. What sometimes you may see that maybe the land doesn't qualify to be in land use anymore for whatever reason. Maybe something's happened, sellers conveyed off a portion of it. If you're continuing it, then how long does that take to get the continuation paperwork? Is the buyer doing what they want to do and filling out the correct paperwork? Your escrow officer can kind of help facilitate some of that for you, at least getting you the correct forms and, telling you where you need to send them to and those sort of things. But we seem to have like a little bit of delay, and I won't say delay because they tell you it's going to take a couple weeks, but the county, they take a while to review these things. So you've got time involved.
And every county is probably different, right?
Yeah, I'm assuming so. Like I know Clark, it'll be a little bit, and everyone knows that, so you kind of have to build that into your closing date. So you're in land use, you want to continue it, maybe don't put it out for 30 days, maybe a little bit further even. So,
okay.
Yeah, that's where I see kind of the hiccups is just trying for us on the escrow end is just dealing with those times because the title reports are going to tell you right away. In fact, the taxes will even tell you, it'll tell you that classification. So you could kind of know if you're just looking at your tax rolls there as a broker. So,
can it even take a little while for the county to deliver the number, the amount?
Sure. Yeah, that's going to take you a few days too. For you're going to tell them, okay, here's what we're doing. We're selling it, and we want to know how much we're going to owe you. Okay, well, let's put our figures together, and that may take a few days. And if you want to be able to tell your seller, maybe you do that in advance, right? Maybe you reach out and say, hey, we're looking to maybe possibly do this. Can you give me a ballpark figure? And I know they'll do that. They'll work with you.
Yeah. So listing brokers, you're the first layer of offense on this issue to make sure that this issue is handled proactively in the negotiation of the purchase and sale agreement. But buyer brokers, you cannot count on a listing broker to have done their job. So when you are reviewing the preliminary commitment for title, which hopefully the listing broker has at least accessed and uploaded as an attached document to the listing printout, and buyer broker, you come along and your buyer wants to write an offer and you're reviewing that preliminary commitment. If you see that the seller's property is held in a special tax classification, make sure you include in your buyer's offer the addenda that you will need to negotiate this issue. And I'm not suggesting that one outcome or another is the right one. What I am suggesting is that since all of you are held to the standard of care of a lawyer when you prepare a purchase and sale agreement, this is an issue that must be addressed in the purchase and sale agreement whenever the seller's property is held in a special tax classification. And if it is not, then the law is really clear. Seller, it's your job to pay those back taxes. So if we get all the way to the closing table, and that's the first time the seller learns that they owe these back taxes, and they refuse to close because they don't want to pay them, more likely than not, seller is in breach of that contract. So listing brokers, make sure you're paying attention. But buyer brokers, that's not a good answer for your buyer either because they want the property. They want to close the transaction. And so just to be able to say, well, the seller's in breach, buyer's not going to have, buyer's not going to lose their earnest money, that doesn't really help the buyer if the buyer's goal is to own the property. So both brokers pay attention to this issue and be proactive to resolve it during negotiations prior to mutual acceptance.
I like that.
Anything else on this issue?
Nope. I think you got it.
If you have questions on this topic or any other, please visit warealtor.org and ask me a question by following the links to the legal hotline. Thank you for being a Washington REALTORS member.